We know police arrested 3 men already, partially, they say, in connection with 15-year-old Alisa Petrov. They're all charged for sexually exploiting and enticing a minor. We saw one of those men, Matthew Menard from Florida, for the first time today for his very first court appearance in Utah County. Take a listen.
Judge, he's in Salt Lake Jail, and they're not on until 2.
He's on. He's in the Utah County Jail.
We got him there now.
Oh,
yeah,
okay.
Looks like yeah, thank you.
Okay, welcome everyone. We're doing another deep dive today, basically tearing open a stack of documents to, pull out the key stuff for you. This time it's legal papers.
Yeah.
From a criminal case up in Utah County.
Yeah, we've got the actual charges filed, the statement explaining why they filed them, a warrant request, and even a court order about media access.
Right. And our goal here is pretty simple. Walk you through what these documents actually say, what legal ideas are in play so you can get the gist quickly. The person named here is Matthew Nicholas Menard. And the charges, they come from the Utah Attorney General's office.
And that main charging document, the information, it lists several counts. Seems the alleged incidents happened roughly January through April of 2025.
And looking at those counts.
They're serious. You got 2 counts of aggravated sexual exploitation of a minor, first-degree felonies under Utah law, big deal.
What?
And then there are also, 3 counts of criminal solicitation and 1 of enticement of a minor. Those are Class A misdemeanors, but still significant. They seem to relate to, allegedly trying to set up illegal sexual activity and lure a minor online.
Okay, so how do they back this up in the documents? What's the foundation for these charges?
That's laid out in the Statement of Probable Cause. It really centers on alleged online chats with a child, just identified as CV1.
Okay.
And a key point in that statement is that allegedly Mr. Menard communicated with CV1 through a social media app and at certain points supposedly confirmed he knew CV1 was underage.
So the document gives actual examples of these alleged conversations.
It does, yeah. The probable cause statement quotes things allegedly said by Mr. Menard like, are you secretly 15, lol? It also mentions CV1 apparently saying they were in middle school.
Wow.
But despite that, the statement says the conversations kept going and, became largely sexual. It even quotes some really graphic statements allegedly made by Mr. Menard, and it describes talk about meeting up involving discussion of hiring a prostitute and sex.
And it goes beyond just talk. What about images or videos?
Yes, the statement also alleges that Mr. Menard instructed CV1 to take and send nude photos and videos, and it claims CV1 did send images described as CSAM child sex abuse material based on specific requests.
Okay, let's shift to the next document. This request for and grounds for a no bail arrest warrant. They're asking for him to be held without bail. Right. Why?
Exactly. So here, the state makes its case based on Utah law. The main arguments presented are, 1, he's a substantial danger, especially to kids, and 2, he's a flight risk.
And the danger argument connects directly to the charges.
Pretty much. The document argues the danger comes right from the nature of those alleged communications, the focus on soliciting sex and CSAM from a minor. That's the core of it.
And the flight risk part, what's the reasoning there in the request?
Well, the document states that Mr. Menard was allegedly doing this from Florida. It says his main connections, his ties are there, and that he has, no real connection to Utah.
Oh.
So the argument follows that he might just, take off, flee the jurisdiction if he were released.
But that danger argument in the warrant request, it seemed to go a bit deeper, didn't it? They mentioned research.
Yes, that's a really notable section. The document makes some strong assertions, citing research that law enforcement and researchers apparently use to link viewing CSAM with actually offending against children in person.
Like specific studies.
Yeah, it mentions studies claiming pretty high comorbidity rates numbers like 50%, 62%, even up to 85% or 98% between people who view CSAM and those who commit contact offenses. The prosecution uses this research in this document to argue that viewing CSAM reinforces deviant interests and makes real-world offending more likely.
So based on that research they cite, they argue standard release wouldn't work.
Precisely. The request claims that because the internet is everywhere and these alleged crimes are so secretive, pretrial monitoring agencies just can't effectively stop someone from getting online or contacting kids.
Even with things like GPS monitors.
Apparently not, according to their argument here. They basically say no conditions can really guarantee safety or compliance. So the conclusion in the document is A no bail warrant is the only way to protect the community.
That definitely spells out their reasoning for the danger aspect as presented. Okay, one last piece. This court order about media coverage.
Right, so this just shows a media outlet asked to cover the court stuff electronically. The court said yes to live streaming, but, with limits. The order specifically says no coverage of minors, jurors, exhibits that aren't public record, or confidential lawyer-client talks. Standard stuff, really.
Reflects the court balancing public access and privacy, basically.
Exactly, trying to keep things fair in a sensitive case, as the order lays out.
Okay, so let's wrap this up. We've looked at documents outlining multiple serious charges against Matthew Nicholas Menard. These are based on alleged online communications, including graphic content and exchanging what's described as CSAM. And we also dug into the prosecution's argument for holding him without bail. That argument relies heavily on the idea of danger, using cited research to link alleged online CSAM activity to potential real-world risk, and claiming standard monitoring isn't enough.
Yeah, and I think what these documents really underscore, especially that warrant request, is how challenging authorities find it, or at least how they present the challenge, of gauging risk from alleged online acts, and how they argue that connects, or could connect, to real-world safety, particularly when they feel traditional methods fall short.
It really makes you think, doesn't it? How bits of digital information, alleged conversations, research statistics, how all that gets distilled down into formal legal actions and these very specific arguments you see laid out on paper.
Yeah.
Definitely something to ponder in terms of how these cases get built.